Hey, welcome to today's video. I'm Richard Chapo. I'm an attorney in San Diego, California, and I represent California businesses. Today we are taking a look at the CCPA, specifically the Gramm Leach Bliley Act exemption. So the CCPA is the California Consumer Privacy Act. It is the new privacy law in California. Goes into effect, part of it does at least, January 1st, 2020, it looks like, with the remainder going into effect probably around the summer of 2020. The Gramm Leach Bliley Act is a federal privacy law that deals with information collected by financial institutions. So if you were to submit, let's say, a mortgage application or something of that sort, it applies to that information. So the important thing to understand is that when there is a federal law on a particular subject, a state law cannot be passed that conflicts with that federal law. The state law will not be enforced. And so the situation that we have here is the original initiative draft of the CCPA had language that did conflict with the Gramm Leach Bliley Act. So that language was removed and this exemption was included. And the exemption can be found at Civil Code section 1798.145 subsection E. You can see it referenced there in number 1. And it reads, this title should not apply to personal information collected, processed, sold, or disclosed pursuant to the federal Gramm Leach Bliley Act. There's some additional language we'll talk about in a minute. That's pretty clear. I don't think there's much to argue about there. One question I have been asked in the past is, well, it doesn't actually say purchased or bought. And that is true. However, the CCPA is drafted in a screwy way. So instead of just putting that language in the exemption, they actually define the word collected that you see there broadly to include the word bought or purchased. So you're okay on that front. Now, you may hear people talk about or read or perhaps see in a video the idea that this exemption only applies where the CCPA conflicts with the GLBA. And that is incorrect. That language was in the original version of the CCPA that was enacted into law. But in September 2018, Senate Bill 1221 was passed and it amended the CCPA and it removed that language. So the conflict language is a no more. And I think we can probably all agree that that's a good thing, because trying to figure out where those two acts conflicted, boy, that would have been fun. Now, there is additional language in the exemption that I did not include, and it references section 1798.150. And it says that the Gramm Leach Bliley Act exemption will not apply if section 1798.150 does. What 1798.150 is referencing is a data breach. So if you have a situation where you are holding information protected under the Gramm Leach Bliley Act and you are hacked, well, the exemption is not going to protect you. The California Attorney General can come after you. Private parties can come after you. In that situation, there is no exemption. And that sounds like it might be a bit worrisome, but quite frankly, if you're already holding this information, you should have a pretty vigorous security system in place. And yes, anybody can get hacked, but if that information is forming part of a database or something of that sort, you really should probably already have your act together in that area. If you don't, or you're not sure, well, now's the time to make sure that you make those changes. Getting hacked and exposing personal information of a financial nature, that's a road you don't want to go down. So we have one final issue: definitions. And this is something only lawyers could love. There is a potential, well, I wouldn't even say potential, I think there is a problem with the exemption in relation to definitions. And simply put, the Gramm Leach Bliley Act's definition of personal information is narrower than what the definition of personal information is under the CCPA. And so any information that you're collecting and claiming is exempt under the GLBA, well, if it doesn't fall within the definition of personal information in the GLBA, and it does fall within the definition of CCPA, well, in that scenario, the exemption would not apply. Now, this is a complex issue, as you can imagine. And it's something that needs to be evaluated by taking first the data, assessing all the data being collected and used and what have you by your client or by your business, and then applying it and comparison to those two definitions. Now, in fact, under the Gramm Leach Bliley Act, there isn't a definition for personal information. It's called something else. But nonetheless, it's the same basic analysis. Anything that's falling in that little crevice between the definition in the Gramm Leach Bliley Act and the definition in the CCPA, you need to address. And so obviously that's something that needs to be looked at rather closely. So anyways, that is it for today. The CCPA and the Gramm Leach Bliley Act exemption. Generally good news for people that are handling financial data. So thank you for watching. Have yourself a good one.